We are live now, Mr. Secretary.
All right, thank you. Welcome everybody to our November 19th meeting of the Juvenile Justice Reform Council. Jamie, if we could go ahead and call the roll.
Sure. Secretary Abed.
Here.
Senator Smith. Senator Carter. Senator West.
Here.
Delegate Clippinger. Delegate Jackson.
Here.
Delegate Pippy.
Here.
Secretary Green. I did see Secretary Green hop on. Ms. Tolentino.
I'm here, thanks.
Mr. Kemerer.
Here.
Ms. Egan.
Good morning.
Judge Stamm. Ms. Douglas. Dr. Gilball.
Present. Good morning, everyone.
Ms. Lawson. I thought I saw Dr. Lawson hop on. Dr. Sickman.
I'm here, thank you.
Mr. Bayless.
Here. Good morning.
Deputy Commissioner Sullivan.
Present.
Mr. Schellenberger.
Good morning, all. I'm here.
Ms. Davis.
Here.
Ms. Mandel. Mr. Dodson.
Here.
Ms. Handy. Ms. Handy's in the waiting room. I'm going to mark her as present. Mr. Campbell. Ms. Chapman.
Good morning, I'm here.
Mr. Fonseca.
Here.
Mr. Houston.
Present.
Ms. Johnston.
Good morning, I'm here.
Mr. Ford.
Present.
And Deputy Secretary McClone.
Good morning, I'm here.
That's the roll, Mr. Secretary.
Thanks, Jamie. And as members come in, please just announce them as we go through the meeting. I know some folks might be coming on a little bit late, and we'll go ahead and move forward. We did send a revised set of minutes out yesterday. If we could take a moment to review those, and we'll entertain a motion to approve them.
I'm not sure I saw the revised set. I saw a set and vote number 4 in the set I have is inaccurate.
Yeah, that's correct. And that was what was updated in Jamie's second email. It came last night, I guess around 6 p.m. But that language was corrected to what we voted on, Senator, which, and I'll read it out to you. It says, establish a plan to transition from DJS's current slate of committed facilities to ensure every region has access to non-residential and residential community-based services that employ evidence-based, culturally competent programming. And I think that's the part that we were talking about.
Yes, that's right. That's good. Thanks.
Thank you.
I would make a motion to approve.
Second.
Okay, any opposed to the minutes? All right, the minutes are approved. Okay, so we have some remaining recommendations from the last meeting that have carried over to this meeting. And on our agenda, you see that we also have the diversion presentations that were also slated for the last meeting, now moving to this one. So I'm going to start here at the bottom for just a moment on the future meetings and just advise that we're sort of in the same posture in this meeting as we were in the last meeting. We'll take the recommendations up. We'll take as much time as we need to discuss them and hopefully vote on them. And if we finish in time to do the presentation for diversion, we'll do that today. If not, then that will move to the next meeting. I know that we only have, let me just speak a little bit about the next meeting, 12/3. That was a meeting that I requested that we schedule, which will put us in 3 consecutive weeks of meetings. And what we're recommending for that December 3rd meeting, which is the one that was added to the calendar in anticipation of perhaps not having enough folks there, is that we will do presentations only on the December 3rd meeting and no voting. So if there is a meeting that you need to miss, or if there's one of those weeks that is out of whack for you, please try to do it on that 12/3 date. We'll have all the presentations posted. You obviously can see all of that, and you'll be able to review the video if you weren't able to attend the meeting. But we do have a number of presentations that are sort of backed up at this point. In addition to the diversion presentation possibly being on that date, we did receive data on the youth charged as adults, but we did just get it, I think, yesterday. And so time that it might be ready for 12/3. With the data since they just got it, but keep you updated on what we're going to do in upcoming meetings as that is available. So for today, we have recommendations both for detention and probation practices. And we had a work group of 2, I believe, working on those recommendations to try to corral them into something that's a little bit more manageable for the council. And so I want to turn it over to Betsy to just go over the sort of revised recommendations and where we stand.
All right, good morning, everyone. You should have received some recommendations in your email from Jamie when you got the agenda. One set is titled on top probation and the other set is titled on top detention. Miss Egan and I took really what the Office of the Public Defender submitted and sort of grouped some things together and also put some recommendations together that were responsive to the presentations and where we saw some consensus building. So first, Sam, do you want me to go over both sets real quick or one at a time?
Yeah, just go over both sets, and I think I want to go back and start with detention when we get to discussion, but please go over both for now.
Okay, I'll start with probation then, and then we'll wrap it up with detention, and then I'll shift it back to the chair. So if you look at your probation recommendations, the first one is return to intake. This recommendation is really based on a piece of legislation that was submitted last legislative session, where the Office of the Public Defender, the Department of Juvenile Services, as well as the Maryland State's Attorneys Association all supported an effort to create a pathway for the court to be able to send a case or a petition back to juvenile or to Department of Juvenile Services intake department for an informal supervision. In a sense, this is a way of diverting a case from the formal court process a little later in the continuum of the process. The next set of recommendations relate to probation duration. And that was a big topic of our conversation when we reviewed the presentations from Vera. Right now, there are really no sort of determinate sort of sentencing or terms for probation or community supervision for young people in Maryland. So this set of recommendations breaks it out by offense type. So by misdemeanor, felony. And then we noted that life crimes, if handled by the juvenile system, should be a little different. So for misdemeanor, we recommended that a probation term should be 6 months, up to 6 months. There could be additional terms for the purpose of completing a treatment program or rehabilitative service after a court hearing, but those terms should be limited to 3-month increments. And then the maximum term of community supervision should be at 12 months. For felonies, we followed sort of the same structure for an initial term up to 12 months with 3-month increments after a court hearing for the purpose of completing a treatment program or rehabilitative service, with the maximum term being 24 months. And then for a life crime, we recognized a 24-month initial term, of course, additional terms in the increments of 3 months, but that the community supervision could continue until maximum age of jurisdiction in juvenile court, which is age 21. The next recommendation relates to violations of community supervision. And we recommended that an intake officer or the court may not authorize detention or commit a child to the Department of Juvenile Services for a technical violation as defined already in the Correctional Services article. And we included that definition for you so you can reference it. Last council meeting, we did vote to prohibit the utilization of committed programs for technical violation already as defined in the Correctional Service article, but I just combined it all here into one to include detention and also include that definition for your review. And then lastly, to really sort of target the types of programs that the department is utilizing, we have a recommendation to put a collaborative together to study, define, assess programs and sort of notify the public and other stakeholders as to whether they're evidence-based. And also, I think an important part of this recommendation is to develop a process to assist existing community-based organizations with assessments to become evidence-based or a promising practice, or to gather some level of evidence to show their effectiveness. So those are the probation recommendations. I'll switch to detention now. First, you'll see on top of the page, detention recommendations for legislative action, and we'll start there. We are recommending that we prohibit the use of detention for any misdemeanor offense except for handgun violations as contained in the criminal or correctional law articles, public safety articles. And that mirrors the language that we utilized for limiting the utilization of committed programs. And then we have another group of recommendations that are more procedural, and that's number 2. In making detention recommendation or decisions, we recommend that the court, in addition to the other statutory factors that are already contained in law, that they shall consider the findings of a validated risk assessment. If the youth is continued in detention, DJS shall develop a community release plan within 10 days of that detention and submit that plan to the court and parties. And that detention status should be reviewed by the court every 14 days. Currently, under the orders from the chief judge, really since the beginning of the pandemic, juvenile detentions have been reviewed every 14 days. The next set of 12 recommendations are really directed at the Department of Juvenile Services. So I grouped those all together, and those are all recommendations that were really things that either the department may be doing, may be considering to do in the future, should evaluate to see if we can implement. So we suggest that we take all those recommendations up together and that the department report back to the General Assembly and of course the council members as to the ability to implement evaluation of those, if we can gather the data that's requested and progress on implementation of those that are currently being utilized within the agency procedures. So I'll turn it back over to you, Mr. Secretary.
All right, thanks, Betsy. And so, yeah, let me just pick up on the piece about the recommendations, the 12 recommendations, detention recommendations that are there. I think that these are all worthy of looking into and evaluating, if not, things like Betsy said, we're already perhaps doing or in the process of doing. And so I think we could consider, as we have discussion on some of these legislative things, I would like to spend our time considering the items for legislative action more than these, and look at a motion that would just accept all of them as something the department should respond to, or give a status update on implementation of. There isn't anything on here that I see things that we certainly can do. There are things that require data reports that I don't think it's data that we already have. It's just a matter of putting it into another report. Some of these things we absolutely can do. Other things I think we need to look into and dig in a little bit more. And so that's why I wanted to do it as a report rather than spend a lot of time debating it. But I want to plant that seed, and then while we're thinking about how we deal with that, turn to the legislative action recommendation here for detention, and open up discussion about the first recommendation here, which is prohibiting use of detention for misdemeanor offenses, except for those handgun offenses and the violations that are contained in the criminal and public safety articles. And I think that those are spelled out on the other recommendation sheet, which those, on the, what are those violations? But let's go ahead and open up discussion for this.
Well, let me just ask, I still have my concern about youths that repeatedly commit misdemeanor offenses. Certainly not for a misdemeanor offense. There should not be detention. But if somebody's out of control and effectively terrorizing a neighborhood, what can we do to prevent that from continuing other than detention?
Yeah, and I would agree, because assault is a misdemeanor, and you could be committing multiple assaults in school. And what are we going to do? I mean, shouldn't there be some exception that even if it's for, good cause found, or for extraordinary reasons, or as Senator West said, multiple offenses, shouldn't there be a carve out at least for a judge to make a decision on that?
So, go ahead. I was just sort of going to ask, most communities that are looking to reduce their detention populations with similar kind of things build up a robust set of alternatives to detention so that you're not deciding between lock them up and do nothing. And I would say that in both these legislative actions, perhaps there needs to be something about that. And that in addition to considering the validated risk assessment of the youth, that there be a consideration for what are those more community-based detention alternatives. Because if you have a robust system of alternatives to detention, that actually lowers the risk for an individual youth, because you have something else to do. You're not just letting them hang at home.
So I know that one of the recommendations for the department here that we've sort of set aside as recommendations to DJS speaks to that, Dr. Sickman, which is create definition and limitations on community detention. I know that it's talking about defining and limiting how we use those things, but it also, by defining it, puts it out there. And Betsy, I do believe that we do have some of these options articulated publicly, do we not?
Yes, so we do have a continuum of alternative to detention services that include shelter, so short time out of home placements, electronic monitoring, community supervision, GPS monitoring is available, as well as evening reporting centers in some of our jurisdictions. We've actually been able to sort of expand our utilization of evening reporting center programming over the pandemic, since a lot of that programming has actually been done virtually. On our website, if you go to the publications page, you can see sort of what our continuum of alternative to detention services looks like in each jurisdiction, and sort of what the definition, in a sense, is of like electronic monitoring. Who's eligible? What does it mean to be electronically monitored? And when would the court be notified of an infraction?
So I just want to also make sure that we put the correct frame and context. The idea that a child who is terrorizing a neighborhood with misdemeanors, whether that be second-degree assaults where there's no major injury, or malicious destruction or jiggling door handles, what we do know is that putting that child in detention makes it worse. So the idea that detention somehow cures or solves misbehavior, I believe, is the wrong frame to start with, because it's just not true. All the research shows us that detention will make that misbehavior for children worse, not better. So the idea that detention somehow would address those problems, I think, is false. And second, I wanted to note that these, we are talking about pre-trial detention. These children are still presumed innocent under the law. So to use an incapacitation that does damage to their development, that takes them out of school, that makes their misbehavior and recidivism worse, is the reason that this recommendation is on the table. So I just wanted to offer that frame and make sure that we recognize the evidence is that detention wouldn't make that neighborhood better and wouldn't make them safer in the long run.
You know, I don't have a problem with setting a very high bar. You know, something high like clear and convincing, or, you know, represents a danger to the community. Or I think, as Dr. Sigmund mentioned, even if we just put in here what you pointed out, Sam, was number 3 below, just an acknowledgement that, you know, as long as other alternatives are available, that would be fine too.
And I would add that it also, I mean, I think you have in here the idea of kind of reassessing if there is a decision to detain, but definitely, I mean, the burden should really be on the adults to do a better job for these children. So whatever you can figure out to put in, you know, if a community is lacking those other resources, that shouldn't mean that the kids get punished before they are guilty because of that. The adults need to be forced to figure things out, to do a better job.
So, Delegate Pippy.
Thank you. So I want to point out a couple things. One, it just kind of dawned on me here, but you know, in many cases, someone is charged with a felony and then that is pled down to a misdemeanor. So you could have a scenario where you have someone that may have actually committed a serious offense, potentially against another individual, and they pled. I mean, we know how the adversarial process is here. I mean, pleadings, it happens every day of the week. So you could have a scenario where someone is not jiggling door handles, but they're actually committing serious offenses. Second, you know, we keep talking about children. I mean, you know, in many cases, these are 16 and 17-year-olds. So I think that needs to be taken in consideration. To Schellenberger's point, I mean, giving a judge discretion, at least in some situations, is probably responsible, because you know, you don't want a scenario where someone was charged with multiple felonies, they pled down to a misdemeanor, and because it's not, you know, anything above that, nothing happens. I mean, that goes right towards public safety, and I think it would be a mistake to not consider those situations.
I thought we were talking about pre-disposition, pre-adjudication detention. And if that's not I mean, we need to specify that then.
We are talking about pre-adjudication detention.
So just to clarify, that means for
But you are
Delegate
correct,
Pippy's
it
point.
doesn't say that here.
Well, it says prohibit the use of detention. And so, I mean, we can say pre-adjudication detention, but I consider detention to be a term of art that describes pre-adjudication detention. If you're talking about kids that are post-adjudication, that's commitment. But we can amend the language and say pre-adjudication detention to be clear. that's what we're talking about. I think that's fine.
Mr. Secretary.
Yes.
So I certainly agree with a lot of the conversation that we're having, that, you know, adults should be held responsible, and that we should come up with solutions, and in some of the other dialogue. I guess the question that I have is, are we sure that there are services available for these kids? So just as Ms. Egan said that sending them to detention, in her opinion, isn't the solution, I don't think the solution is do nothing. So I guess the question is the infrastructure in place to do something for the children now to help them? And I know that a lot of people, especially coming from my office, they're going to say, yeah, Glenn, send some more money. But we know that you can't just send money and fix the problem. It takes time to set these programs up and have these solutions engaged. So I just want to make sure that we're talking about that as well, that we have some solutions for them.
Sure. I think that's a good point to bring up, Glenn, and we do have services available. And so I do want to sort of broaden the conversation a little bit and talk about situations where, you know, if we have underlying issues, and typically when we're talking about kids that are continually misbehaving, they're not just doing that in a vacuum. There may be some other underlying issues. And so when we're saying that we don't want to use detention is a very specific response, a system response. If there is an underlying mental health issue, then there may be a need to hospitalize somebody or to bring them in for those types of acute care. And the mental health system and the Department of Health is capable and still capable of doing that. If there is an acute issue of neglect or abuse that may be triggering some of that behavior, DSS is still capable of taking and removing that child, Department of Human Services, of removing that child and responding to address those needs. And if we're just talking about a sort of knucklehead that continues to do a low-level offense, yes, there are other avenues that the department can take. And so some of those avenues are using the types of strategies we use for diversion, alternative dispute resolution type of things. Holistic responses like community conferencing are options that we could use if we have kids that are in conflict and trying to resolve that underlying conflict. That's still an option that we would have, and that schools or police would have. We still have options, you know, I mean, there are many options, all of the sort of diversion options, like the choice program that we talked about in a couple of other programs. We can provide supervision and structure around that kid. If they need treatment, we can go further and provide treatment in the community if they are adjudicated for an offense. So there are a number of responses that the system can have. What we're trying to prohibit here is that taking somebody out of their home and taking out of their community preemptively, saying that this misdemeanor is so egregious that even before we have a trial, we're going to put you into jail and let you wait there until your trial date. And for misdemeanors, I think that what we're saying is that's not an appropriate system response. And that's really how we need to look at this. There are many other responses. I think it's fair to want to look at those responses, but there are many other responses short of detaining somebody and restricting them from their freedom, which is the most extreme response that the system has. That's the biggest thing that we can do. If you commit the most egregious crime, that's the biggest thing that we can do. We're talking about the misdemeanor offenses and saying, can we pull back on doing the biggest response, the biggest deprivation of rights for these misdemeanor offenses. And you know, so I think if we want to amend the language to require us to post in every jurisdiction the range of alternate responses to detention, I think that's fine to do, and I think we can certainly do that.
You know, I think to that point, Secretary, you know, I think having that education of what services are available is important. I think one of the things that I've found as we continue to do the work that we do is that there are a lot of services available and people simply aren't aware of them. So I don't know that it's posting, you know, something, or do we work with Maryland 211, or do we do what do we do to make sure that people are aware of these services for diversion and deflection? I think that's a great idea.
So
Yeah, I think that the approach that we've taken, and I'm gonna let others talk. The approach that we've taken is really to try to educate the band practitioners about what the options are. When we talk about the practitioners, the public defenders, and the prosecutors in court, but we don't do much to really educate the public about what's available. And that's probably where an area that we're deficient at, and that's probably causing some of this anxiety. I saw Nate and Dr. Sickman, so let me go with Nate first, and then Dr. Sickman, then Jenny.
I think,
I'm sure there are others.
Lynn's hand's been up for a while, so I'll let her go before me. I saw her.
All right.
There. It's kind of hard to scan all that stuff.
Yeah.
I just wanted to say that, we know that other states have gone to low detention rates before us, California, Florida, Delaware. Can someone speak to the success that they've seen in their views and their take on detention?
I'm happy to weigh in. I don't know that Maryland at this point itself is having a pretty low rate of young people in detention. And I think it is the approach that we've heard about. It's not just about alternatives. It is about being clear about the purpose of detention and making sure that it's not only in statute, but it's actually being lived out in practice. And almost every state has some sort of statement of what purpose of detention is. And it's very limiting in terms of what we should be using detention for, just as this conversation is suggesting. So I think that it's not just one thing. It is about the front door of detention. It's about the back door of detention, how we're getting young people out, making sure that cases are moving through court. It is about as Maryland is actually taking a lead on, I think, around the country, looking at racial and ethnic disparities of young people in detention, making sure we're responding in specific ways. It is looking at, as we're suggesting right today, what we would talk about as looking at, let's say, special populations, which typically means looking at violations of probation, warrants, what are things that are holding young people in detention where they could be dealt with in the community. So it's sort of all of that. It is looking at the data, looking at how young people are screened in the first place. It's all those things. And I just want to I'll just add a comment that I'm glad Sam brought up community conferencing. And to me, I think here we have an organization in Baltimore, like Restorative Response Baltimore, that is to the very concerns being raised by, I think, Senator West and others, is one that is about not just, is there a service, but is there a sense that there's an understanding of wrong and of harm? And are we doing something to repair harm that's being done in a way that is actually towards change? Like, that's the thing that we're looking for. And I think where Ms. Egan was going is that if a young person is repeatedly causing harm in his community, even if it's in minor ways, but that they add up to being greater than the sort of sum of the parts, putting him in detention where he will stay for some short period of time only to go back and be more angry and more scarred and more detached from his community, it doesn't do anything. It doesn't have any purpose, whereas there should be a deliberate effort that is about understanding what is going on and allowing people to be able to explain why what he's doing is harmful if he's harming his community. So I guess I think you have a model. You have a model here in Maryland. I don't know, to the point of not everybody knows about it. Like, you have the kind of a program right here in Baltimore that other places around the country, to Ms. Davis's question, are also utilizing, which is looking at restorative justice, not just as this idea of a program, but as a way of a philosophy of making sure that we are focused on the harm that is done, and that people should have a voice in helping a young person understand the impact of their actions that may seem small and may not seem like they impact other people. And so I'm glad that it was brought up by the secretary, because I think we haven't talked a lot about it in these meetings, and yet here it is. You have something right here in Maryland that other places come and look at what the model here in Baltimore to understand what they're doing and why that's impactful.
I know there were others that wanted to speak up, and I don't want to.
I was just
Okay,
going
go
to
ahead,
suggest
Dr. Tickman.
that it might be useful to develop sort of a structured decision-making guide that, in addition to considering how this youth, scores on a risk, you have misdemeanor, you're assessing some risk of detention. If there's a decision here to no longer detain the misdemeanors, it's still a useful process to force decision makers to, actively, kind of like a pilot goes through a checklist, to consider what are those alternatives, and is the youth appropriate for this? Do they need that other support in the community also? To do that for the felony kids too. I don't think it should be an automatic that every felony kid is being detained. It's too costly. It's costly in terms of just the dollars that it costs to detain a kid, and also because of the actual harm caused by detention, so that the kids, you've actually increased that kid's risk of future offending. So, have maybe, as part of the suggestions that are numbered down below, to develop that kind of decision-making guide, and clarify for me, who is it that is making that initial detention decision? It's not usually a judge.
Yeah, it's the
That's later
department that makes the initial decision. So yeah, what you described, Dr. Sickman, is we do have a tool that guides our initial decision making, and that we do have that, and we share that with the stakeholders with the outcomes of our D-Ray. But I want to maybe come back to something that Mr. Schallenberger brought up, which was an exception, and explore that. I think that is an option that may have some legs here. Can you repeat or reframe that, Scott?
Oh, sorry. So where was I? Prohibit the detention for a misdemeanor. I think I was saying, unless proven by clear and convincing evidence that the youth is a danger to the community. And Ms. Egan, you can help me if you want to set a different standard. Well, you probably don't want to set any standard.
I'm thinking about it. I'm thinking. Hold on.
Okay.
I'll just say that I don't want to set any standard, but
Okay.
I'll just note that those exceptions are usually used, you use an exception and it's easy to drive a truck through it, right? So how do we prevent that exception from being applied to every child, right? So say a child is, I'll just tell everyone on the council, like I've had judges say a kid who jiggles door handles could piss someone off with a gun, so they're a threat to community safety, right? It's just such a broad term that I wonder if we don't limit that to actual, to forms of violence or something more specific. And then I just wanted to note that as we talk about this exception, this council voted overwhelmingly last time to ban out-of-home commitments for misdemeanors. So it's very confusing to me that we're debating whether or not a child pre-trial who has not been found guilty should be put in a jail cell when we've already, as a whole group, 28-2, decided that that child should not be taken out of their home. So I just don't understand why we would say a child could go to jail for a misdemeanor when they have not been found guilty, when we've decided they cannot be taken out of their home and sent to a youth prison after being adjudicated.
I was part of it too.
Senator West.
Yeah, so we have a detention facility in my district. It's called the Hickey School. Sam, what is the story of Hickey? That this is in existence right now. Is everybody that's being detained at Hickey, have they committed or allegedly committed felonies? Or are there some people at Hickey which have allegedly committed misdemeanors? And if in fact we have all these alternatives that you ran down the list of, that are available right now, and there are people in Hickey who have committed misdemeanors, why are they not being treated in one of those alternate ways? Why are they at Hickey?
Well, to answer your question, I mean, the population has changed a bit during the pandemic, but typically the majority of the kids that are detained at Hickey or at any other detention center are there for misdemeanor offenses. And I say majority, easily more than 50% on any given day. Right now, our numbers are more towards we have fewer misdemeanors now as a result of some of the changes. And I think we've talked about some of these things with the chief judge's order and so forth that have changed our numbers. But typically there are a high number of misdemeanor offenders. And the simple answer, and I don't want to gloss over anything, is that it's just that's what a judge decided. That this person should be detained. Now, some of those misdemeanors that you'll find in detention are those handgun violations. So that would account for some of those that are accepted here in this rule. But there are a lot of other kids that are in there for misdemeanor assaults or misdemeanor property crimes. And they could be, I believe they could be served in the community.
Now, so let me do a follow-up. You've been doing this for years. Are you quite confident that if we passed this and prohibited use of detention for any misdemeanor offense except handgun violations, and we use these alternative diversion techniques that you talked about at great length, that would be successful in ensuring that young people who are misdemeanants would not continue to terrorize their neighborhoods?
So will kids continue to do things that they're not supposed to do? Yes, they probably will continue to do things that they're not supposed to do. And I think that is the sort of conundrum we're in when we're talking about kids with undeveloped brains. You'll tell them that you're not supposed to do this. They understand that they're not supposed to do this, yet their impulsivity shows that they do it again and again. And will this prevent that from happening? No, that's not going to prevent it from happening. But incarcerating them also does not prevent that from happening either. And so the question is whether it is incarcerating, if it's not going to get us a better result, why should we do that when we can use some other form of intervention that is at least as effective, and our data shows that actually is more effective when we use alternatives to detention. And we do have a report. I don't want to go so far into the data, but when we look at kids that are and we do have cohorts that we can compare because of so many kids being in detention for misdemeanor offenses, we can actually look at groups that are similarly situated, some that are detained, some that are given an alternative to detention that have very similar sort of criminal histories and backgrounds generally. And when we look at their outcomes, the kids that were not detained, that were given that alternative, have had better outcomes, significantly better outcomes in terms of recidivism and coming to court, the kinds of things that we look for in terms of public safety. So, we have a model that is ineffective. We've done a comparison, and doing it the other way is more effective at getting that behavior change. I can't say that it's going to be 100%. No, kids are still going to go out and continue to do things as kids always do until they mature and stop behaving that way. But I think we can get better results doing it this way than we're doing it the current way with using detention for misdemeanor kids.
I would be remiss if I didn't talk about the disproportionate impact of using detention for misdemeanors, not just on Black children who are detained at much higher rates for lower level crimes, but for young women. The proportion of young women who are detained for misdemeanors and first-time misdemeanors is astronomical compared to that of young men. So what we see, Senator West, and what I see in my practice is that all too often when our other systems fail children, they use DJS and the detention system as a warehouse. So often young women who are being detained should be a part of the DSS system, but when they are detained for their own safety in DJS, DSS will not open a case, will not address their needs, will not take care of those children. And the same is true for the mental health services. I think what we are seeing is that far too often DJS is being used as a warehousing service when other agencies and other adults should be stepping up to provide services for these young people. That detention does nothing to help and only harms.
So I just want to make a suggestion here. I think that there is enough sort of debate here that we may need to table this for some time and try and work on some language about addressing the misdemeanors that or repeat misdemeanor offenders. I would like to just put a pin in this one. If we can, because I don't think we're moving really towards a vote on this at this time, and look at the second recommendation and see if we can move on that one. So the second recommendation here is in making a detention decision, and I think these are separated recommendations. They don't need to be taken together. Making a detention decision, the court, in addition to the other statutory factors, shall consider the findings of a validated risk assessment. And if the youth is continued in detention, that the department shall develop a community release plan within 10 days and submit it to the court and the parties. And that detention status shall be reviewed by the court every 14 days. I think Betsy mentioned that the 14-day reviews are something that are currently already happening. The other pieces there are to add a plan, which would be just to give that option to the court, which I think is fairly consistent with the conversation that we've had here, is that we want to give options. It's not taking or requiring the court to act on it, but that they would have to review that case and review that option and consider the risk assessment tool. Any thoughts on that? And just to be clear, I want to table number one for later today, not to table it for another day. I think we're getting there, but we just need a little more work on that one.
I would at least, kind of add the specification about it being pre-adjudication detention to avoid confusion.
I noted that.
Yeah, we'll make that change. Thank you, Betsy.
Well, if it'll speed it up, I have no problem with this one.
Nor do I.
Okay, well then, do we have any motions? I'd say Rosemary.
I was going to say, if you're ready, we could move to consider this, then we could have a second, and then we could continue discussion, or we could have a vote. So I will make that motion.
Thank you. A second?
Second.
All right. I think we could probably do voice vote on this one. Is there anyone opposed to this recommendation? Jamie, do you find that acceptable for unanimity?
Sure. I mean, it's up to you. That's not uncommon to do a voice vote like that. I guess I'm not sure if Judge Stamm wanted to be recorded as abstaining on that one, or I just thought I'd point that out.
I'm in a rock and a hard place. I know what I'm supposed to do, but I'm sort of in the same sphere as the state's attorney. So officially mark me as an abstain, but everyone knows what I really think.
Will do.
All right. I think we've got, good, we got one under our belt here. So with that, I'd like to turn to the probation recommendations. We went through them, or Betsy went through the probation recommendations earlier in the meeting, and the first one was the return to intake. Does anybody have any comments or motions on the return to intake recommendation?
I would make
If
a
you have one.
motion to,
Actually,
it's Betsy.
I've got a question. What is the second sentence all about? It sounds like it requires unanimity. Why is it important to require everybody to consent to go to intake?
So that is really the compromise between the Office of the Public Defender, the Maryland States Attorneys Association, and the Department of Juvenile Services from last session when we were developing this proposal for the General Assembly. So if you think about the continuum of when this sort of happens, this is after a young person has been referred to the Department of Juvenile Services, and we forwarded the petition to court. So we're at the point where the matter may formally be dealt with by the court. So if all the parties are there and maybe something happened over those 30 days, maybe there's a new piece of evidence that became available, or there are times when the case is forwarded just because there's restitution due, maybe that's able to be resolved, or there's just a treatment need that the parties have agreed should be dealt with outside the formal system, then everyone would agree just to send that back to the intake office for that pre-court supervision.
Okay, thank you for that explanation.
And I would make a motion to accept the return to intake recommendation.
Second.
Okay, any discussion?
I just was going to ask, is this the same as whatever the proposed statutory language was that was kind of put forward last time?
I believe it is.
Yes.
I do too. I believe it is. I think it's what we agreed to.
Mr. Chairman, I again have lost the thread here. I can't seem to find the document that we're talking about. Is this the part of the JJRC's recommendations on detention dated 11/19?
No, I'm sorry. This is, we've moved to the probation recommendations.
Okay.
So that should be the other document. It
All
also
right,
says.
I see it. Okay, thank you.
My apologies. I should have been clear about moving over to this document. Okay, so any other discussion on the return to intake recommendation? All right, let me ask, is there any, I think we're going to just go ahead and mark Judge Stamm as an abstention. But is there any opposition to this? Okay. Hearing none, I'm going to accept that recommendation as passed. And let's go and move to the probation duration recommendation. Now, this is the recommendation that put limits on the duration of time that probation could be for or imposed upon a youth for misdemeanors, a different standard for felonies, and then life crimes were essentially accepted from this, although there are requirements for the court to renew the probation term, but they can renew all the way up until age 21. Any discussion on this?
I had a question.
Dr. Sickman, go ahead.
You know, we know that using both incentives and sanctions as part of an approach to community supervision is more effective than using sanctions only. And one very effective incentive is to allow youth to have time taken off their length of supervision. I didn't want any of this to be, to get in the way of that, and wondered whether there should be some language somewhere that would allow that, so that, if the youth is doing everything that's required of them, under supervision, that they could have, some days, weeks, even months, to shorten their term.
Yeah, I think we would have to have some sort of, definitive probation term in order to implement something like that. But I think it's something that could be made part of the graduated response system. But I think that I would like to sort of keep that separate from this conversation. This is sort of just the guardrails. I think that's sort of an enhancement we could put on there.
And I would say I was thinking about that, and there's nothing in this language that would prohibit that as far as I could tell. And it seems like this gets at the core of some of our previous discussion about sort of the identity of probation within DJS, the practices of probation officers within DJS. And I think that should be a big part of it, what their own recommendations are when young people are doing well, I think, Melissa, as you talked about last time, we want to reward them when they do well, as opposed to probation being about catching them when they do something bad. And I think that's a great example of that. But I read this and wondered myself, I don't think it didn't seem to prohibit anything like that.
All right. Any other thoughts or comments before we entertain a motion?
This is Scott.
Yes, go ahead, Scott.
So I have no problem with the first paragraph or the third, but the second, you're completely limiting probation to 24 months. And I mean, that's how I'm reading it. Just yesterday in Baltimore City, I read in the newspaper that 12 individuals were arrested as juveniles for carjacking. Some of them as young as 14. And suddenly we are saying you can't even put these folks on probation for more than 2 years. I mean, I just think that when you have a situation like that, there needs to be at least a call out. To have a carjacker at the age of 14, have 12 of them and say, oh, sorry, when they hit 16, no matter how they're doing, you can't have them on probation anymore, even if they're doing a good job. And Nate, I agree. If you're doing a good job on probation, I think the department can always ask that they shorten it. I have no problem with that. And if we want to put that down somewhere, that's fine. But I just feel like there has to be, again, should be limited to 24 months unless for good cause.
So can I just address that? Part of this and the reason that we came up with this is that there is commitment, right? So if, for example, somebody did a carjacking, the judge is looking at the individual, not the charge, right? So if that judge looked or magistrate looked at the individual and thought that they may need services beyond that period of time, they have the option of them committing them. So that's why this is tiered, right? The commitment lasts for 3 years under the juvenile statute. This would be felony probation would be maxed out at 2 years and the misdemeanors at 1. So it creates a tier that doesn't mean that those children couldn't be on supervision for longer. It just brings it in alignment with that. Because right now what happens is that probation is not limited, right? So a kid with a more serious charge may have their supervision ended at 3 years, where a kid with a less serious charge who just keeps doing okay, right? Who just doesn't quite fall in line, but never does anything serious again, can have their case go on and on and on. I'll also note that 2 years for a 14-year-old is a significant portion of their life. It is literally it is more than 10% of what they remember in terms of their development. So don't underestimate what 2 years means to a 15-year-old or a 12-year-old in which is, some of our current cases.
It actually means a lot to a 61-year-old. So again, I don't know. I understand the 2 year point, but I don't understand if somebody's on probation, they're marginal. I can't believe, Ms. Egan, that you want to say, if you want to continue them, you have to commit them. If the agent is still working with the person and trying to just keep a control over it, it just seems to me probation would certainly be a better option than any kind of commitment, just so you can lengthen the time. And we can put in here, there's a preference to leave it at 24 months max, unless there's good cause.
Okay,
Can I?
oh, I'm sorry.
Sorry, I'm sorry. I understand the point. I'm struggling with the logic. So we have someone who's put on probation at whatever it was, 14 years old. I'm just using this example. He's been on probation for 2 years, doesn't pick up another arrest in the 2 years of that time, doesn't come back into the system for anything, but he's just not listening. He's not following the plan that the state wants him to follow. He's not doing the things we want him to do, like going to school, maybe being home when he's supposed to be home, listening to his parents, all that stuff. But he's not coming back to the attention of the legal system in any way. I'm just trying to understand the thing that has us, after 2 years of that, which I think earlier was brought up, of like, whose failure is that? In 2 years, if we're not connecting with this young person in a way that's got him going into something else, is it his failure or is it our failure? But he's not. The basic thing that we're trying to do is to not have him keep getting in trouble with the law. And we're saying he's not doing that during that time, or else that would just be a new case and we'd be starting all over again with the clock. So I guess I'm trying to picture in my head the case that would be extreme enough of the scenario we're talking about, that would require after 2 years of being on probation, which would probably be sometime like 2.5 years perhaps since the alleged offense. Like, I don't know. I'm just struggling with why we would need that as a thing. I hear the point, but I'm just no new offenses, because we're specifically not talking about law violations. We're talking about just non-compliance.
Ms. Chapman.
Yeah, so I would agree. 2 years in teenage years, whether you're 14, 15, of successfully completing, and you're going to school with peers, you're going, competing against all of the odds that are against you. If you successfully complete during those two years, we should be rewarding them with allowing them to go on with their lives. And then if after that point, if something happens, then we loop back to that piece. But we can't hold people hostage for what we think may happen, because at that point, if we're saying that, oh, we think something may happen after that, then we are setting people up for future failure. And that's not fair to our young people. And we can't think, kind of in my mind, our minds at, our age or 61 or whatever, that's a short time for us. But in teenage years, that is a very long time with what they're dealing with.
Dr. Sickman?
Is there anything that if you have a child who hasn't committed any new offenses at the end of 2 years, but still kind of isn't thriving, is there anything that would prohibit other agencies from providing services to that youth and their family?
No, there's no prohibition. If they're receiving services, from another agency, I don't think it would have any bearing on that.
Yeah, again, I agree. I think it's, shame on us if we didn't do our best job and have failed that child, but the child shouldn't continue to be sanctioned.
Yeah, and my sense, I'm sorry, I'll let Ms. Egan go in just a second. My sense is a lot of these cases get, continued on probation for long periods of time, not because of really the need to supervise, but it's like restitution becomes an issue and it just kind of hangs out there for periods of time. Is there, from the practitioners, is there a sense that we have, real behavior issues that are extending people beyond 2 years on probation?
I just want to address that briefly and some of the concerns that have been raised. It's not just that the child has committed no new offense. It would also be if the child had not had any violation of probation, right? Like if there was something that had raised the level of concern, or that the behaviors were so extreme, their probation would be violated. so we're talking about a child who committed an offense 2 years prior and has had hasn't been found guilty of anything new and hasn't had their probation violated. I'm failing to see the scenario here, or it feels like we're boxing a red herring that doesn't exist.
Well, could I ask a question? So
Absolutely.
I don't know the answer to this, so that's why I'm asking the question. So if one of the terms of probation is that the youth go to school and the youth fails to go to school on a regular basis, is that a violation of probation, which would enable the Department of Juvenile Services to then revoke the probation and put the child in a committed facility?
Currently, yes. Under the recommendations we made last meeting, no. But it doesn't mean that they couldn't commit them. You can commit a child without putting them in a facility.
Okay.
To the Department of Juvenile Services.
Detention here. So let me rephrase it. So long if a child fails to go to school during those 2 years, could the DJS put the child in a detention facility and revoke the probation?
So there's a prohibition to using detention or incarceration for that kind of a status offense. So going to school is a status offense, or not going to school is a status offense. Incarceration is never appropriate in those circumstances and would violate the federal law.
Scott, I assume you're still with us. Give us an example of the kind of situation that you would be concerned about and where you think that the standard should be unless for good cause. Give us an example.
Well, what I was thinking about is, the individual has been on probation for, I could keep coming back to carjacking because that's the one that kind of really worries me. But now they're not going to school. That, as Ms. Egan indicated, they have not committed any more offenses, but they're not going to school, not doing what they're told, not doing what their things, the things that they're supposed to be doing on probation. And yet, all I want to do is allow them to be on probation longer so we can work with them. I don't necessarily agree that the solution is to commit them so that we can stay with them. So, I mean, that just doesn't make any sense to me. If commitment is, in my mind, worse than probation, why are we doing nothing and letting them back on the streets for roaming whatever way they want, or committing them as the only options, as opposed to having an option of continuing the probation for another 6 months to a year? I don't know.
Let me just offer the other counterfactual, right? Is that there's lots of parents on this call. The idea that we would take any 16-year-old who's not listening to their parents' rules or not attending school, and somehow the state or probation would change what being 16 is I just don't understand what probation is aimed to do at that point, except for what Mr. Schellenberger said in his last comments, which is control. And that control is exactly what we're trying to move away from a command and control into an opportunity-based positive youth development. If we are not offering that young person something in those 2 years, the failure is not with the 16-year-old, the failure is with us and with the adults in the room. We know that that DJS has limited resources, that we need to focus on very high needs kids. We have kids with significant problems. And when you keep misdemeanors on probation for 3 and 4 years, just to continue to scold them and try to make them go to school, we are taking away resources from our multiple carjackers, right? From somebody who has committed crimes of violence, from young people who actually need a high level of services. So I just want to note that this isn't just in a vacuum. When we talk about keeping kids on for longer, we are taking away resources from the kids who have multiple offenses, who need to be out of home, and who need much larger interventions than low-level offenders who haven't made a mistake in over 2 years in terms of delinquency or crime.
So, one of the issues I want to just maybe come back and reframe a little bit to what one of the things Dr. Sickman said which was at the beginning of this, having a sort of set number of months or whatever it is for probation gives you the opportunity to whittle it down for good behavior. It gives you the opportunity to provide a powerful incentive for the young person to perform. And I think that's the benefit of having a limit on the duration or a cap rather than keeping it open-ended. It's the open-endedness that is, sometimes very difficult to explain to young people, particularly if they've done what they thought was necessary to satisfy the court. To have it, extended is sort of the most difficult thing to deal with. So as we're looking at this recommendation, is there a term that is reasonable to anyone that is uncomfortable with the 24 months? Let me throw that out there.
I mean, any limit you put on it is going to be artificial. And that's why I don't know. I just don't see it making any sense to me that in 2 years we're making some progress, but not enough with this individual, and we're going to suddenly, give up on them with this artificial deadline because we want to push our resources to somebody else, and we'll just either commit them or wait till they do another crime so Mr. Schellenberg can charge them as an adult. I mean, it just doesn't make sense as an option.
Okay, Betsy, I'm gonna ask you to use your memory banks here for a second. And I know that we had proposed, there was legislation proposed at one point to put some limits on probation duration. How did that legislation look, and compare it to this?
Previous legislation has been introduced by, I believe, maybe just in the House. Can't recall if it was actually introduced in the Senate as well, to identify probation terms and put it into two different categories: what the probation term should be for misdemeanor and what the probation term should be for felony. And I believe those drafts landed on 1 year for misdemeanors and 2 years for felonies. But I'm going to ask Jay Johnston to go ahead and look that up for me and shoot me an email with the actual numbers so we can be sure. But there was no end date. The legislative proposal allowed for multiple terms to continue after a hearing and good cause was found until the age of jurisdiction. Sam, you're on.
Yeah, sorry. I think that I'd like to give a little more time for this recommendation and get some additional information. And so I'm going to put a pause on this one as well. And let's move to the next one on the sheet here, which is violations of community supervision. I do want to just take a look at what those other proposals had in terms of the probation duration and see if we can fashion something that is satisfactory to our group here. But let's look at, while we wait for that information, the violation of community supervision recommendation, which is that an intake officer or the court may not authorize detention or commit a child to the Department of Juvenile Services due to a technical violation as defined in the Correctional Services article. So this is essentially taking away the option of incarceration for technical violations, with the exceptions that are noted below. And these are the exceptions that we discussed at our last meeting on the commitment restriction. Those are the types of technical violations that are like no contact orders, and then absconding as another area that are technical violations for which you could be violated for and incarcerated. So that's how I understand this, and I'd like to just open any conversation on this. Or any motions.
Move to adopt.
I believe I heard a motion to adopt, but I didn't see who said that.
That was me, Hannibal Kemerer.
Okay, Mr. Kemerer has made a motion to adopt that recommendation.
Seconded.
Okay, Ms. Egan seconded. All right. Any discussion? All right. Is there any opposition to this? Yeah, Scott, I did scroll over to your screen to see. All right, I'm not seeing any opposition to this. I think this is a good recommendation. And so I'm going to assume again that Judge Stamm is abstaining. And if there are no opposition, there is no opposition, we will take this one as passed. All right. So we still now have the probation duration and the back to the detention recommendations. We have still outstanding the first detention recommendation. And then we have the 12 recommendations for DJS action. And I would like to entertain a motion on those. And if somebody could perhaps craft a motion that requires the department to respond to each of the recommendations within a year of the report's submission to the legislature, or something to that effect.
Can I just say so moved?
I think that'll work. Thank you, Glenn.
I can second that.
I'm sorry, I got mixed up. Which one are we on?
So this is back to the detention recommendations sheet. And these are the 12 recommendations that are directed to the department. And the motion would be to have the department respond specifically to those 12 recommendations within a year of the submission of this report, the JJRC.
At the same time, I have no objections.
All right. So we have a motion and a second from Senator West. Is there any objections or opposition to this? Okay, hearing none, we'll assume Judge Stamm is an abstention and that this passed.
So Sam, I have an idea on the probation. I came up with some language. So on
right.
the one that says 24 months, if we added, unless for good cause shown and proven by clear and convincing evidence that extending the probation would be in the best interest of the child. So now you're making me prove it for good cause, a high standard on clear and convincing evidence, and we're doing it for the best interest of the child, that the probation could be extended.
And then is it unlimited?
I could certainly agree to some time period. I mean, at this point, we're now in we're dealing with an individual that a probation officer knows and a judge knows. And so, I mean, obviously it's limited till they turn 21, but if we want to pick an artificial date, I guess we could. I just feel like for a 14-year-old carjacker, 2 years might be too short.
Do you think we could agree to 36 months, which would peg it to the limit of commitment that's already in the statute? I know it's arbitrary, but it is an arbitrary law that already exists. Would
All right, so everybody's head won't blow off. I'll agree, yes.
I mean, I think
That's
having a
just-
limit kind of puts the fire on probation, you know, like you have a deadline to do a good job.
And that comes back to the
Not
adults.
just a deadline for the kid. You know?
It comes back to the adults. Sure, we can put an ending on that, 3 years. No more than 3 years. Total.
Right. So the area and the last line of the recommendation, the maximum term of community supervision shall not exceed, that will be amended to 36 months. And then the language that Scott, you were inserting, I would like to get that into a document that we could share on the screen, because that's getting rather large at this point.
You mean now?
I'm sorry. I thought we were saying the 2 years would still be the thing, and with the ability to, in all the special circumstances that Mr. Schellenberger was saying, we would go to an
Add another
extra
year.
12 months on top of it, not to set it at 36 months.
That was my intent. I believe, Ms. Egan, I don't want to put words in your mouth, but I thought that was your intent.
Yeah, can we accomplish that by just changing that cap on the back to 36? Rather than, because the standard about best interest of the child, that's already the standard. So my question is on that, could we just say if the child is adjudicated, all of those things, and just change 24 to 36 at the bottom of that clause?
Or do you want to encourage a limit to 24, and then if there's the clear and convincing evidence, whatever he said, it could perhaps go to another 12 months to 36?
That was my intent. I believe, Ms.
I
Egan.
think that's the way to do it.
That was my intent. The preference is 24, unless I can prove by clear and convincing evidence for good cause shown, then it can go an extra year. And I will try and get that typed right now if you want to move.
I'm happy
Well,
to type and put it on the screen, Mr. Schellenberger, if that's helpful. I have the recommendation here.
Great, thank you.
All right, great. While we're waiting for Betsy, Ms. Davis, you have a comment?
Yes, would that include continuing to review it every 3 months? So that the child doesn't go from 24 to 36 and doesn't have a chance to get off it before the 36?
No, that's my intent.
Okay.
Continual review.
Okay.
And are we maintaining the 12 months for the initial piece? Okay.
Yeah, I didn't want to change paragraph 1 or 3. It was just 2 I was focused on.
Mr. Schellenberger, this sort of presupposes, if it's clear and convincing evidence, that there's an evidentiary hearing. Is that right?
Yeah, and so I'd have to prove something in a courtroom why we got to do it.
One thing I just want to say, because I'm glad we're going through this, but I think in the and I understand that we're wanting to put forth recommendations that can be voted on, and yet I know in previous meetings as we talked about probation, we talked beyond the sort of technical boundaries of probation into the purpose of probation and what we're trying to accomplish. And I feel like we always have 2 different conversations that are happening at the same time here. We talk about something that's very technocratic, and then there's always these concerns about real life people, the people living in communities, the young people who are involved in the system. And I think part of why Mr. Schellenberger, why I'm sort of was digging in on this one in particular, is because if we aren't attempting in the 2-year period that a young person is on probation to make probation irrelevant in his life, we are failing, badly failing here. That the probation should be about connecting this young person to other people in his community and in his life who are working towards helping him change his behavior and helping him work towards something positive. And if we're still relying after 2 years on a probation officer at DJS of being some sort of hammer that's the thing that's going to keep him in line, we are so off course from what we should be trying to do with a young person on probation that I just don't want it to get lost in this discussion, the right discussion about technical limits on these things, to miss, I think, the concerns that I know Senator West keeps bringing up that get at the like spirit of what are we trying to do with young people who are on, what's our theory of change? What do we think is actually happening? And I think I appreciated through this that DJS knows that a lot of this is on DJS from a practice standpoint about what's happening and the things that are already changing within the agency. But I just don't want to lose that point as we get into these things. And that's why I'm sort of stuck on this thing of like, we're putting it on the kid after 21 months. I get this exception, I'm okay with the exception, but it just feels like it gets us lost in a technical thing that misses what are we actually trying to do when young people get in trouble? What are we trying to, do as a system?
So Nate, what I'm trying to say is I'm putting this on Sam and Betsy. And I'm saying, look, you got one more year to fix this, because please don't forget, what is the alternative? The alternative is to put him in Hickey, or I'm going to see him in adult court. And so we all don't want to do this another year to try and help him. And I agree, it's on the agency, not necessarily, and as Ms. Egan has pointed out, it's on, trying to fix the family maybe. But all I'm saying is we want to have our options to be commitment or go to adult court when you commit another offense, as opposed to giving it one more lousy year, which can be cut off if I can show for good cause. And I'm done. I'll be okay.
Yeah, I think, Nate, just to respond to what you're saying, you're absolutely right. This doesn't address the sort of cultural change that, we want to have in the way that we administer youth on probation. But this is to set the guardrails so that, some of the sort of worst outcomes, the worst outcomes that we've had sort of don't occur. And it's not complete. This isn't the whole thing. And I know that, your foundation has a targeted intervention for probation. And I think that's something that we certainly want to engage with, but these are just the guardrails. We're not getting to that higher level here at this point. All right.
While
Go
Ms.
ahead, Ms.
Tolentino,
Egan.
while Ms. Tolentino is finishing drafting that, I wanted to return potentially to the detention for misdemeanors and offer a compromise position that I think might address some of Senator West's concerns. I was wondering if we might be able to get to consensus if that new language said to prohibit the use of detention for any misdemeanor offense except for misdemeanor handgun violations, unless the child has 2 or more facts sustained in the previous 12 months. So this would be if this was a third misdemeanor and the child had been in trouble twice in the last year, then that could authorize detention. And that would sort of address and get to the young person who is, on a misdemeanor annoyance crime spree. And I wondered if that might get us to consensus. So prohibit the use of misdemeanor offense unless there's been 2 or more facts sustained in the previous year. I limit it to a year so that we're not talking about a 17-year-old who comes in with a new school fight and they're not being punished for something that happened when they were back in middle school.
Would we still include the carve out for handgun violations?
Yes.
That would solve my problems. I'm not sure what you mean by facts sustained. Isn't there a better way to say that?
No.
That's the term in juvenile court. It's a guilty.
It is? Okay, great.
Yeah. That
All
just
facts sustained. It's a guilty finding. But
All right,
that's
as long as people know what that term means, that's fine.
I actually can agree to that amendment.
Again, I would add in the pre-adjudication.
Yeah. So Jenny, if I could ask you to draft that one up for us and insert that use of pre-adjudication detention and then the additional language that you mentioned, and then we'll take a look at that as well. All right. And I'm trying to find my Betsy screen. Are you ready to share any document yet, Betsy?
Can you hear me?
Yes.
Okay, I don't think I'm moving. Let me see if I can share my screen and put that up. Can you see that?
Yeah, we can see it.
All right. Whoops, I was going to try to make it bigger, but I really might mess everything up. Let's see. Okay, so I think we have it here where I added in, I kept everything the same. I mean, you know, the additional term we don't want, I'll probably need to change this language a little bit. But I added in, Scott, if this is reflective of what you and Jenny were saying, probation may be continued beyond the 24 months to a maximum of 36 months if after a hearing the court finds by clear and convincing evidence good cause that extending community supervision is in the best interest of the child.
You said the word evidence, it's just not typed there. But if you type that there, then that was my intent.
All right, is that better?
So Betsy, maybe if it says probation may only be continued beyond 24 months, then the prior sentence could come out.
Oops, I'm sorry, where are you?
That maximum, the maximum term shall not exceed 24 months. If you took that sentence out and added the word only after maybe in the next one. And maybe is 2 words there.
Yeah, gotcha. All right.
May only be, maybe that's the way to do it. We got English, you know, that's a challenge.
It's a challenge. There we go. Well, Microsoft doesn't like it, but I think it is reflective of the conversation.
Okay, I think that does get the language right. And let's just double check once again with Scott. Does that make,
yes.
Does that satisfy?
Yes.
All right. So
I'm good.
Excellent. So do we have a motion on the probation duration recommendation as amended?
I'll move.
I will second.
Okay. I'm going to ask again if there is any opposition. And Betsy, yeah, stop sharing. Thanks, so I can see everyone's
All right,
faces. You got it. We're good. Again, I'll just ask if there's any opposition. All right. Hearing none, we'll mark Judge Stamm as an abstention, and the motion carries.
Sam, I can work on sharing my screen. I believe I have the language and I can share it. Again, just give me one moment for the detention recommendation as described by Ms. Egan.
Okay.
Sam, I think as a chair, you need to sing right now to give us some time. So
Seconded.
I was going to do the do 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 do, but that's like Jeopardy. That doesn't give you much time.
Sam, there was a section on the probation thing of using evidence-based, outcome-based services that we didn't talk about yet.
On probation recommendation. Oh,
a whole other page.
Yes, you are.
Sorry.
You are right. We will take that up in just a moment. I think that I'm sensing that Betsy is close to having the language, and oh, there goes the screen.
Okay. I can't find my Zoom button. Wait. Sorry, am I on mute or off mute?
Well, you're not muted, but okay, now we got your screen back. There you
All
go.
right, sorry. It's hard to share screens. All right, I think this is it here.
Yep, that's it.
Okay.
I'd make a motion.
Wait, shouldn't that be an or? So it says contained in the criminal and public safety articles, or the child has 2 or more facts sustained in the previous 12 months. So if it's a misdemeanor, we can hold them. Or if it's another kind of misdemeanor, not a handgun, they have 2 or more. I think that was the intent.
Agreed.
And probably unless could come out.
Agreed.
I like it. Is that a second?
I'll second.
Okay. Let me ask, well, if there's any discussion on this. Is there any opposition? Would like to be heard? Okay. Well, then we'll take this as passed with the one notable exception of Judge Stamm's abstention. And go to the forgotten recommendation that Dr. Sickman pointed out. All right, so we have one remaining recommendation, which is utilizing evidence-based / outcome-based services. And perhaps either Jenny or Betsy, you could just refresh us on this one.
I have to find it. If you have it first, Jenny, jump in. I need to go back to another screen.
I too have to go back, but I'm opening it right now. So this is some of what we talked about in our recommendations about developing an inventory of what quality services are for young people. We've seen systems like California and Washington actually go in and create a real list so that we can measure and judge which programs are effective for young people. This would be calling for the state of Maryland to one, study which one of those are evidence-based, research-based, and promising practices, and then to develop a way for community programs and existing programs to validate their successful programming. So this is a way of creating an inventory and creating better array of services across the state. That's the aim of this. Happy to answer questions about what that looks like.
So this sounds reminiscent of the Washington state model. Is that sort of what we're going for here, but without as much data analysis, perhaps?
This is actually modeled exactly on that language. So this is the original bill that Washington passed in 2012 with some slight edits. In that what they found is that those forms of validation tended to privilege very large, well-resourced programs and not create an on-ramp for existing community-based programming. So this is that Washington model with 3-III added to it so that we can create an on-ramp for smaller programming and create a way for community programs to validate their success rather than just simply cut them out of the calculus.
And I was going to sort of ask, I don't know whether it belongs as part of this or as a separate thing, the issue that Nate had recently brought up about we just need to have the approach to probation be more of that coaching and connecting to the community and less about control and sanctions. As a general, what is the purpose of it?
So for me, this meets that in some ways by forcing the state and the department to start looking at what really works and what exists in our community that supports our kids. So although it doesn't do it formally, it certainly creates the mechanism so that we can start to have those broader and deeper conversations about what works, what is working, and what is unique to Maryland that we're doing well.
Do you think that it maybe as a, I hate to have an add-on to, well, that was for detention, but something similar to, the list of 12 things for detention, that we could task the agency to really sit down and craft a new and different kind of purpose statement for the agency and what probation supervision is all about?
You could do a sentence that right before this whole section about what you're going to try to adopt, and mention it is the intent of the agency to pursue what Dr. Sigmund said. That it's kind of an underlying theme.
Okay.
Yeah, in terms of the sort of policy of what we should use probation for, I think certainly the department can weigh in on it, but it seems to me that the legislature is the policy setting arm of our government. And if there was to be a statement about the purposes of detention, it probably should be articulated in the code. I don't know that we can roll that up into this recommendation, or if that's just something we should, have a recommendation that we, have a purpose articulated in code, but that's sort of where I feel about that.
Well, Sam, I'm envisioning, because I know it's going to happen, is you, Betsy, and I testifying in front of a legislative committee, trying to get them to give you more money to adopt these things. And therefore, I think we need to communicate as this body that this is what our intention is. That's why I just kind of jumped on what Dr. Sigmund said, because we're going to be having to justify all this to somebody. And they need to understand that this group feels like this agency needs to shift philosophy. I don't know. That's what I envision.
So rather than try to wordsmith it today, I think I'm going to ask Dr. Sigmund, if you could, since you've raised it, to just articulate a policy statement, if you could, over the interim before our next meeting, so that we could consider that. I know our next meeting is not a voting meeting, but we can vote on that in a subsequent meeting. But I think it's a good idea, and I think that's something we should do as a JJRC. We should set or try to articulate a policy statement on the use of probation.
Okay, I might recruit Nate to help me.
I'm sure he's willing to participate. Okay. So back to the recommendation here. I do have a couple of questions. The first line here, a Maryland State Institute for Public Policy. Is this proposing to create that?
No. Just identify one that already exists.
Oh, okay. So use some existing state institute.
Yes.
And then University of Maryland Evidence-Based Practice Institute. Is that basically the Innovations Institute is that entity, right?
I think that there are various ones that could shop for that. I think that there's one there's various ones, but yes.
Okay.
And this way, if that funding or structure changes 10 years from now and that innovation doesn't exist, then that would, we would have to identify a different body within the University of Maryland system. But yes, you want to leave it open-ended.
But the goal, though, of this recommendation would be to house the information and the data analysis and the publication kind of stuff within that institute. Is that?
Yes, that's correct. I would just also note to Scott's point about fiscal resources. This is also because the federal law changed in terms of what gets reimbursed and funded. So being able to show that things are evidence-based also allows the department to get a higher level of reimbursement back from the federal government. So this is also about making sure that we identify programming that is is evidence-based and create a way to verify so that we can get more funding for these programs and get reimbursed by the federal government at a higher percentage.
Secretary Abed, I just mentioned that in terms of getting that kind of funding and the grant dollars, that's a lot of what our office is focusing on right now, is looking at evidence-based and bringing that data together to show impact.
Okay, I appreciate that. So that'll help us with the inventory section of this, and it is a good point, and we are working to get as many of our providers to be recognized as qualified, whether it's qualified residential treatment providers or other types of providers that we can fit in the definition of candidates for reimbursement. 50% reimbursement from the federal government makes the state dollars extend quite a bit further. And so in terms of the piece about trying to get other sort of local entities into that evidence-based continuum, I very much support that. I think that is very important, and it addresses one of the concerns I've always had with sort of one of these, models that requires evidence-based, is that, it stifles innovation. I think having this piece in there addresses that and satisfies that part for me. Nate, did you have a comment you wanted to make?
Yeah, I just think I appreciated where Ms. Egan was going about the reimbursement, because I think part of the point would be, one of the benefits is it stretches programmatic dollars so that you can invest in newer, innovative, yet to have evidence behind them, but are new ideas that just because they don't have an evidence base yet doesn't mean that they're not better than all the stuff that's in the evidence-based catalog. They very well could be more promising. And knowing that there are a lot of young people in Maryland who have their own ideas about what types of programs they may need, that offers the opportunity to create space for other things that may not fit this, or maybe just funding that is available for the stuff that's more about opportunities for young people and less about the more sort of therapeutic interventions that tend to fit under this type of catalog. And that by getting reimbursed, you have the ability to do more. This isn't about sort of narrowing the pie. It's about expanding it and making sure that young people have access to things that have evidence behind them, but also that it gives the flexibility to have funding that's going towards things that are about more than just our like justice system responses to young people, and about connecting them to things that they are looking to do as well.
Go ahead, Dr. Sickman, go ahead.
So for this kind of sort of, having this, database of things that work and a process for making judgments about the new innovative things, do you want this institute, entity, whatever, who's going to ever be doing this, to also provide training to those service providers and within the agency around evidence-based stuff?
Yeah, we do, of course, but I think that at least with the ones that we have in existence, the evidence-based services we have, there are sort of built-in training requirements that for their in order to be recognized as evidence-based. I don't know exactly how that gets done, but I do think it flows through the Institute currently. Betsy, could you elaborate?
So currently we have a structure that is not too far away from what's being proposed. What's being proposed is definitely more comprehensive and sort of takes us more forward looking rather than just sort of understanding what we're currently we have in our continuum. But the Institute of Innovation at the University of Maryland is sort of like our technical assistance provider for evidence-based services in Maryland. And they monitor all the evidence-based services we have to make sure those services are being implemented with fidelity. They also give us those data reports and monitor the ongoing effectiveness as well as utilization. We are engaging with the Institute to sort of accomplish some of the things that are in this proposal. mainly as we bring in new evidence-based services to Maryland, we want to develop a process to be able to build capacity within our existing community-based organization structure to deliver those evidence-based services. So the Institute is there. I think this proposal sort of takes us to the next level of bringing in some additional stakeholders, as well as, directing us to expand that continuum, and as well as at the same time, support more community-based organizations to become evidence-based.
Yeah, I mean, I just wondered whether there should be any language using the word training and technical assistance that's in this proposal.
I read it to sort of include that, but I think we can be specific. Jenny, do you have any?
My first instinct is that step 2, and we have to get to step 1. But and so to get there, and then the second step will be now that we have this inventory. But I'm open to fixing that however you think is appropriate, Dr. Sigmund.
Can I just really quickly, as we're having the conversation. Thanks. As we're having the conversation about evidence-based and innovative practice, can we just make sure that we're also keeping culturally responsive front of mind and in our language as well, because that's just as important as all of this, because a lot of the frameworks around evidence-based and all of those are very mainstream. And so it's very important that we are keeping that culturally responsive, culturally sensitive language at the forefront of all of this as well.
So I would actually ask that in that language that we make sure that every time we say evidence-based or research-based that we add culturally competent, which I think is not there. But I agree with Ms. Chapman for sure.
Yeah, I think that's an easy fix. We can put those in, put that phrase in, just as you suggested, wherever we see research or evidence-based come up. Let's just insert that word. And I don't know who's going to be doing that. Betsy, do you have the document in front of you? I don't think we need to see it.
I have the document. I'm adding it in. I don't know if it's something I need to share.
No, I don't think we need to share it. I mean, let's just, we know that it's in there.
I'll make sure it's in there, and then Jamie, I'll make sure that you get whatever I've typed up today.
Okay. Is there a motion on this recommendation?
So moved.
Seconded.
Okay. I'll ask once again if there's any opposition to this recommendation as amended. All right, we'll take this one as passed with the notable abstention of Judge Stamm. And I believe that is all of the recommendations that we had to review for today. We do have a few minutes left, but I'm gonna just, I'm assuming, Marta, that that's not enough time for your presentation. If I can find you. There you are, you're muted.
No, that's not enough time, and that's fine. We'll move it to the 3rd. So we'll have 2 presentations on the 3rd for diversion and youth in adult courts.
Okay, so we're going to have a lot of, yes, please go ahead.
Delegate Jackson, good morning.
Delegate.
So Mr. Secretary, if I could, if you could address it now or offline, my office and my committee have received some emails regarding a COVID outbreak at Backbone Youth Facility. So if you can give us an update on that. I do sit on the COVID work group. We had a follow-up from the Maryland Department of Health yesterday. So if you could actually, if you can address it now, I'd appreciate it. If not, if you need to get back to us, please let us know. If certainly don't want any of the youth endangered, but definitely none of the staff who are responsible for the youth to be endangered up there on that facility.
Sure, Delegate Jackson, and I think it'd probably be more appropriate for me to talk to you offline, and I can give you a call directly. But I'll just briefly tell you we do have an outbreak at Garrett Children's Center, formerly known as Backbone, or excuse me, Backbone is still there. I'm talking about Savage Mountain. But all of our Western Maryland facilities are experiencing positive COVID cases right now, and I think that is corresponding with the increase in community spread, particularly in Allegheny County, is seeing a very large spike up. And so we are obviously doing the mitigation strategies that we typically have been doing. We keep people in small groups, both youth and staff, so that if there is an outbreak, that we try to limit it spread within the facility. We do contact trace within the facility using our camera system, so that we can actually look and see whether people were appropriately wearing their masks, or if there were exposures that we need to be concerned about. And then we notify folks if they need to quarantine, that they need to, and how long they need to stay out. And then we do go back and retest. And so that's basically what's going on right now. But I'll contact your office and we can get into more depth.
Yeah, please. Thank you very much.
Absolutely. Okay. Well, I think with Marta, your comments about we're not going to be able to do that presentation today, I will entertain a motion to adjourn.
So move.
Second.
All right. Thanks, everybody. And we hope to see you back on